Very good morning to you. Welcome to today's webinar, What Families Need to Know About Planning for a Loved One with Special Needs, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's presentation. This is the first of many presentations covering topics related to special needs planning throughout the year, and we're glad that you're here. So welcome to everybody. When you have a question for Steve, please note it in the questions panel on the right-hand portion of your screen, and we will take time throughout to address your questions. Your questions really help the presentation. They add a lot of value and help others learn, so please don't be shy in posing your questions at any time. You also receive the presentation by email from me to take notes on it if you wish. The presentation is also available in the section marked Handouts in the panel on your screen to download at this time. Welcome to our professionals as well. For CFPs, CPAs, and others on today's webinar, you may receive 1.5 continuing education hours for attending. So please email me your ID number if I don't have it as soon as possible, so I can submit your CE hours for approval as soon as possible. Everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a few minutes to fill out this very brief survey to offer us your feedback about the presentation. And as always, we read and value every comment. Here at Elville & Associates, we want to be a resource to you for your families and your planning needs. So consider a consultation or a document review with Steve after today's presentation, and use today's education as a jumping off point to get your planning started or updated. Consultations are a great way to get your specific questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. So briefly, I'd like to offer Steve and the firm a proper introduction, and then we're going to jump right into the presentation. So I'm going to share my screen here. You should be able to see it right now. So Elville & Associates, we were founded in 2010 by Stephen Elville in Columbia here. We have many different practice areas that we offer here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do focus on and offer a lot of education here at Elville & Associates. We do that in several ways. Through our planning processes with our clients, we offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning, with an emphasis in areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me, and I'll be very happy to share our story with you when we have just a little bit more time. But for right now, we're going to talk about special needs planning and all there is to know about that. And we have a poll that we're going to start off with. And the poll is pretty simple, but we like to get to know our audience. And the poll is, please tell us what has brought you to today's webinar. So I'm going to go ahead and launch that poll and take just a minute to let us know what's brought you here today. Votes are coming in quickly. We appreciate you being here on this blustery day. Hope it's nice and warm where you are, though. We'll give it another few seconds here. Okay, so we have 29% say I need to set up planning for a loved one with special needs. 26% say I have planning in place, but it needs to be revisited. 14% say I'm a financial advisor here to learn to better serve my clients. And 31% say I'm an interested family member here to gather information. So we have a varied group here for you, Steve. Welcome to everybody. And Steve, I'm going to go ahead and make you the presenter.
Thank you, Jeff. I'm getting the technology in order here. And hopefully you'll be able to see my screen here as I start the slideshow.
Looks good.
And if you see that, Jeff, I think we're ready to go.
I do.
All right, thank you, sir. And good morning, everyone. And thank you for being here on this Friday morning. And it's my extreme privilege to be able to present to you today. And thank you for taking your valuable time to be with me this morning and with Jeff. And I can't tell you just how enthusiastic I am about being with you to do what we really love to do, which is educate about special needs planning and the importance of getting special needs planning in place and getting it in place in the right way. And I hope wherever you are this morning, you're warm because it's an extremely cold day and they tell me it's going to get colder later on and tomorrow. So stay warm. Jeff is a very, very good golfer, and so is his son. And Jeff tells me he won't be out on the practice tee today or tomorrow, but I know he'll get back out there as soon as it gets warmer. And speaking of Jeff, I'd like to thank Jeff for everything that he does. Without Jeff, I could not do what we do here, and all of the associates and attorneys and staff here at Elville and Associates. And so we're extremely privileged to be able to be involved in the special needs community and be with you here today. And I know many of you have questions about getting planning in place. Many of you have questions. Thank you for your responses. You have questions about your existing plans. We have advisors and CPAs of all kinds maybe on this call, and those family members who are concerned. So what I want to do today is educate and give you a path forward with substantive information that you can use. And you're going to have questions. Jeff is an expert moderator. He's going to take those questions and interrupt me at appropriate times. And we're just going to get started here with about a little bit less than an hour and a half of information, and we're going to leave time for your questions. So again, thank you, and let's get started. So planning for a loved one with special needs is really about your individual goals for that loved one. And again, there are professionals, and then there are parents, and then there are other family members. All of you have your own goals in mind and your own values and what you want to bring to the table for your loved one, no matter what level of their disability that they may be. So the overall definition here is to really enhance the person with disability's quality of life and really making sure that they have everything available to them that is possible without restricting their potential. So the good news is we're living in an age where we have supported decision making now in Maryland and in many other states, which recognizes the upside of someone's potential, at least in theory, to say that someone does have unlimited potential, and we don't want to restrict that potential. And that's a different subject that we can get into at another time. But I would define special needs planning as enhancing your loved one's life without restricting their potential. And a maybe more practical way of describing it is to create a world, beyond public benefits where there's another safety net above and beyond the public system. And not all persons with disabilities are involved in the public benefit system, and we know that, but the majority are. So we're going to try to recognize both of those types of situations today, but that would be a starting point about why we should plan. And of course, there's many benefits of planning. Some of these are intuitive to you, but for those of you who don't know or have never thought about this before, I'm going to teach this morning as if you don't know anything, but I realize that many of you do have some of these concepts in mind. So we want to provide financial security, of course. We want to leverage means-tested public benefits. We want to have a team in place. And as Jeff and I many times do on these webinars, we are intentionally redundant in mentioning some of these concepts so that we can drive home these key points. So having a lifetime team in place, whether that is just a financial advisor and an attorney, or in a better scenario, a financial advisor, an attorney, a CPA, meaning a tax professional, and an advocate for your loved one. And I know these are not easy questions to resolve. And that also may include a life insurance professional or others. We want to plan for appropriate housing because we know many of you are concerned about the housing situation for your loved one. As we go to the next bullet point, who is going to provide ongoing advocacy and caregiving in certain situations? Will my loved one be able to live independently or not? Coordinating the entire family's response. Hopefully you have a harmonious family, and if not, we want to talk about that and we want to deal with that in some way. We want to protect the beneficiary from the potentialities in the world of bad things, such as creditors and fraud and predators and the bad things that can happen to them because they are most likely vulnerable persons. And for some of you, it's going to be important to preserve assets, even though this is difficult to think about, beyond the lifetime of your loved one with disabilities. And for some of you, that's a priority, and for many of you, it is not. But it is a basic idea of preserving assets for other heirs. So again, as we talk through these concepts and drive home substance, that's what we're trying to do today. We want to have the right team of advisors to advocate for your loved one during your lifetime, of course, and after. We want to make sure that the plan has flexibility. Now, I'm going to talk to you in certain ways throughout this next hour and a half about flexibility and how to deal with that. I think we all would agree, can't speak for you, that we're living in a very fast changing world. Every day brings new challenges. We have a changing tax environment, a changing political environment, a changing world overall, concerns. So we want to build flexibility. So as I mentioned, we want to have this advisory team. We want to have advocates, and you want to understand the concept of a trust protector. So the ultimate part of our discussion today is going to revolve around the planning through the use of special needs trusts and other techniques. But a trust protector is a special fiduciary who can give flexibility in the future, both now and in the future. And if you've not heard of this concept, we will explain it further in this presentation. So let's talk about what it means to create an effective plan as we try to grapple with how to get started. So we want to spend time thinking. A few years ago, and I think it was right before COVID, Jeff and I had given so many webinars, and our other associates here at Elville and Associates had given many, many webinars. And we came to a conclusion that giving our clients time to think, especially our families with a loved one with special needs, those families, you need more time to think than most families do because you don't have the time, and we know that. So we want to give you the time to think because this can make all the difference. For example, I'm sitting in a very large conference room here in Elville and Associates office in Columbia, and we have 4 conference rooms, but all of our conference rooms have technology and all of these things that hopefully help us as we think through issues. So that's a really important concept, is being able to do something simple like take the time to think. So who will your loved one live with, and where will they live? What kind of care will be required? Does your loved one have a higher level of care that will be required, or are they more high functioning and independent? Will a conservator or a guardian be necessary? Or do you have a conservator or guardian already in place, meaning maybe you are the guardian of your loved one? Who else will need to be involved? What kind of lifestyle is desired? Now, many of these things have to do with your current lifestyle, your current level of assets and financial wherewithal. But if you're younger and or older and you're wanting to plan for greater wealth, obviously the advisory team is important to work with possibly a financial advisor in that regard. What are the future challenges that could be anticipated? How do we build layers of protection? And I know many of these things are overwhelming. I'm just rattling these bullet points off, but if you can just trust me for just during this call, during this webinar, to get your mind around the idea that it is possible to build layers. None of us have all the answers. We know that you are facing challenges in this way of thinking, but you can build layers into your planning. You can build security into your planning. You can have flexibility. And to do that, we need to understand our purpose, which I talked about in the beginning. And we have to understand that time to think involves a process. So a good special needs plan is going to be one where there's process. So let's talk about one of the major portions of your planning, which would be to create a memorandum. So lots of information. I hope you're taking notes. I hope you have a pen or pencil or a tablet, but I'm just going to keep going under the assumption that you will ask questions and you're writing some things down that catch your attention. This is one of those things that you should write down. There are millions of special needs trusts, and then there's certain terminology that we use for supplemental needs trusts. They're 2 different things, technically speaking, but they're similar. And those documents, there are millions of them. And there are millions of non-special needs trusts, as you can imagine. But only a handful of these, relatively speaking, have what is called a memorandum of intent. Some people would call this a letter of wishes. So a good special needs plan, in my opinion, not just a good one, but a really exceptional one. If you were to say to me, Steve, how can we create a special needs plan that is just superior? It is the epitome of perfection. It's going to include a memorandum of intent. The memorandum of intent is going to tell the world, tell the trustees, tell the advocates, tell them about your loved one. What are their preferences? What are their eccentricities? What is their health? Who are the persons in their life? Who are the family members that you want them to be able to visit and be socialized with, and so forth? This is something that, of course, many of your initial trustees will already know this information, but I would not take that for granted if I were you. I would assume that none of your fiduciaries, your trusted advisors, or the persons who are going to set forth or carry forth your plan into the future, I would assume that these people don't know anything. And of course, that's not true. But the future trustees, the people that might be serving in the future, many years from now, many years after our passing, those people may not know anything about your loved one. And I want you to make that assumption. When you're creating this memorandum of intent, which is not easy, it could be 1 page, 2 pages, or it could be 20 pages. It could be an entire manual that you create for your loved one. We have a template that we can give you to help you get started on this. So if you would like to see this template, creation of a memorandum of intent exercise, we are happy to send that to you. This is arguably the most important thing in special needs planning, other than the framework that you will put in place to protect your loved one. Now, many of you are financially savvy, and I'm kind of preaching to the choir. Many of you have financial advisors or CPAs or an advisory team, but many special needs families do not have this. And my experience has been more often than not that families with a loved one with special needs struggle in this area. And so if you are struggling in this area, I want you to know that we will help you. We will help you get connected with a financial advisor and CPA and form a financial advisory team so that you can use their resources. Now, here's what I mean by this bottom bullet point here. We want to use the resources of these professionals because the resources are vast. The financial projections that can be made through Monte Carlo simulations and other types of projections, and that not only to mention the projections that CPAs can do, can be extremely valuable to you. So I strongly encourage you to become affiliated, if you're not already, with a financial advisor or complete team of advisors, and utilize their resources. Don't be shy in this regard, because this is critical so that you can start taking those steps towards planning for perfection in this area. This is an old-fashioned spreadsheet. It looks like Jeff's got a question. I'll stop, Jeff.
Yeah, just thought it was an appropriate question here to ask at this time. Does Elville and Associates have a network of trusted CPAs and financial advisors they work with or recommend?
Thank you for that question. The answer is yes. The main reason why we have these kinds of professional resource tools at our disposal is because we've given workshops and training to many financial advisors and CPAs over the years. And so, yes, we do have those, and we are happy to help you get referred to one or more persons so that you can interview them and see if that is a good fit for you, which is so important. So thank you for that question. So here we have an old-fashioned spreadsheet. Many of you are wizards with spreadsheets, so I don't want to bore you with this. And you may have other resources that you could equally find just as good on the internet at this point. But the idea is that we want you to utilize the resources that are available to you. Now I'm going to switch gears just for a moment, and we're going to talk about your loved one's potential capacity or incapacity. So let's talk about this very, very quickly in a way, because of the other materials that we have to cover. But this is not a small point, even though we're only going to spend a few minutes on it. For someone who has capacity, they have the legal and mental capacity to be able to understand the nature of decision making. That loved one of yours can sign an advanced medical directive and a financial power of attorney. Now, it is our job, not as medical professionals, because we are not medical professionals, but it is our job, sometimes through the help of medical professionals, but from a legal point of view, to make a legal determination of capacity. So a high functioning person with disabilities can execute financial powers of attorney and advanced directives. And what are they doing other than making decisions? What are they doing there? What is the underlying thing they're doing? Well, they are appointing their agents. They may be appointing you. They may be appointing other relatives as their agents. And when they have agents, what do we know about that? Well, we know that when they have an agent, there is no need for guardianship because that person has capacity. They are appointing someone to make their decisions if they cannot do it themselves. So what I would do, just in the best explanation of this slide, I would maybe take your sheet of paper if you have a pencil or pen, and I would draw 3 columns. And in the left-hand column, I would write what is in this first bullet point. I would say this left-hand column represents the person who has the mental capacity and can sign advanced directives and powers of attorney. And what is, again, the point of all of that? That says, if I cannot do it myself, I have agents who will help me who will actually make my decisions, if I cannot do it myself. Now, on the opposite side of your piece of paper, if you're writing this down, we have guardianship. And that's what we're getting here in the middle of these bullet points. What if your loved one does not have the mental capacity to make their own decisions, and they either are already under guardianship or there should be a guardianship of their person and property. This is planning for that person's incapacity. So the guardianship is the highest form of intervention. It is the opposite of this other column. Here, the person cannot make their own decisions and needs protection, broadly defined. A more simple way of thinking about this is perhaps the person is very vulnerable, and of course they cannot make their own decisions and they need a guardianship. Now, in the middle, I want you to write supported decision making. And many of you on this webinar may have heard of supported decision making, or you may know already that Maryland passed a bill, a very broad bill for supported decision making in October of 2022, just a few months ago. And this is a brand new thing for Maryland. If you live in Maryland, there are several other states that have supported decision making. And as we get our minds around this left column, which is the advance directive and power of attorney, my agent will make my decisions for me if I can't do it myself. Over here, we have guardianship. I can't do it myself, therefore I need protection, and that's what guardianship is for. In the middle, I want you to think about supported decision making as a middle of the road. It is somewhat difficult for some families to understand, and that's another subject. We have a webinar if you would like to watch this on supported decision making as it continues to evolve as a concept. But here's how I would describe supported decision making if you don't know anything about it. Supported decision making basically says this: I'm going to be able to make my own decisions to whatever extent that I possibly can, provided that I have the support of my supporters to do so. So supported decision making basically says, I'm going to make my own decisions with support. And this is a little bit of a simple concept, but in another way, it's kind of complex to get our minds around. So society is recognizing that a person could have an advanced medical directive and a power of attorney, appointing agents to make their decisions if they can't do it themselves. But if they can do it themselves, which they will in this example, they will do so with the support of their supporters. And the bill is very broad. And if you would like to know more about it, of course, there are many articles on this, but I wrote an article in our former newsletter, a prior newsletter than to our most recent one. And Jeff would be happy to make that available to you if you would like to get a very broad overview of what supported decision making is. My last point on this slide is that if your loved one needs a guardianship because they are vulnerable or for other reasons of protection, it is possible in Maryland now for someone to have a guardianship and still have a supported decision maker as part of the guardianship. So this is a very, very new thing, but I would encourage you of thinking about capacity and incapacity planning on this continuum that I just laid out for you. Now let's talk about public benefits. Now you'll notice at the bottom of this slide, I have the words critical for trustees. This is critical because we are choosing our trustees very carefully. Nothing could be more important. We have a webinar on that if you would like to watch that, how to choose trustees. But many trustees may not fully understand public benefits, and this is important, not only for you to understand it as much as possible, but for your trustees to understand it. And Jeff, I'm just going to stop for just a second to say a good book on this, and there are many books, but a good book, I think, for laymen and for non-professional trustees is a book by someone that I have a lot of respect for who's in California. His name is Kevin Urbash, U-R-B-A-T-S-C-H, U-R-B-A-T-S-C-H. Kevin Urbash is the former or maybe even the current president of the National Academy of Special Needs Planners. He wrote a book called How to Administer the California Special Needs Trust. Now, if you ignore the word California, which I strongly encourage you to do, it's an excellent book. You can get it on Amazon, and it's going to explain to you the world of public benefits and how a trustee should think about these issues. Other than that, it's an excellent book as well. Speaking of using three columns, let's look at these three columns here, public benefits at a glance. I want you to walk away from this with some substance. You don't have to memorize everything, but you just need to walk away with some basic concepts. The person who receives SSI, supplemental security income, is a person who is being means tested. That person cannot have more than $2,000 in their name. And many of you have a loved one who receives SSI. So SSI, by its very nature, is means tested. It's strictly regulated by the Social Security Administration. And the person who is on SSI gets Medicaid, or in Maryland, this is called medical assistance, automatically. So let's just say that is the quintessential definition of disability and means tested benefits. Moving into the middle column, we have someone who is receiving Social Security disability benefits. And in the special needs context, what we are dealing with is a person who either has their own work record, which many times is not the case, but it is oftentimes the case, where someone has their own work record and they eventually qualify for Social Security disability on their own work record. But more times, oftentimes than not, the person with disabilities does not have their own work record. And this means that even if they were receiving SSI, they will probably eventually receive SSDI at the death of their parent or prior to death at the retirement of the parent. And this means that if they were disabled prior to age 26, if they were disabled prior to age 22, I meant to say, this person is a disabled adult child. So the person who transitions from SSI to SSDI is a person who is a disabled child who is disabled prior to age 22, and they are going to receive a certain amount equivalent to 50% of their parents' disability retirement, I should say, from Social Security when that parent retires, and 75% of that amount at their deaths. Now, the reason I emphasize this, even though it's very ambiguous over this webinar, is that most special needs families that I deal with do not know this. So I hope this, if you've never heard of this, I hope this is happy news for you, which means that if your child is on SSI, when you retire and at your death, if your child was disabled prior to age 22, they will be a disabled adult child status, and they will get a higher amount, most likely, than they were receiving from SSI. On this far right column, we have the person who is either receiving Section 8 benefits or veterans benefits. I'm going to focus on the Section 8 benefits because the Section 8 benefits, if your child or loved one is receiving public housing benefits through HUD, this represents special problems in the sense that any distribution to them from a special needs trust can cause and will cause their rent to go up. Now, there are strategies to use an ABLE account to get around this problem, but the point I'm trying to make is that this is a special situation in and of itself that has to be dealt with. And for those of you who are really interested in the latest, I just received news the other day that the HUD rules are changing, and there are going to be new parameters that special needs planning attorneys are going to have to grapple with that have to do with the new HUD rules. So stand by for that if your loved one is receiving HUD benefits or could receive HUD housing benefits in the future. So back to the middle category here, we have a situation where someone who was receiving means-tested benefits from SSI and Medicaid transitions to the middle column, and you'll notice that they receive Social Security disability, but they also could very well be, and many people, millions of people are, also receiving Medicaid. So the person who receives SSDI will receive Medicare, and they will continue to receive their Medicaid benefits. So this could be a person who is, let's just give a common example. This could be a person who is in the waiver system. This is a person who is receiving Medicaid and waiver benefits. They're receiving means-tested benefits, but now they're receiving Social Security disability, which in and of itself is not means-tested. So SSI is means-tested, SSDI is not means-tested, but now the person is receiving SSDI, They're receiving Medicare as a result of getting SSDI, but they are still receiving means-tested benefits. So they're getting all three, and that's why a special needs trust or supplemental needs trust that we're going to talk about here in just a few minutes, that is still a very important thing. Even if the person is not in that SSI category, they have now transitioned to the SSDI category, but they are receiving means-tested benefits nonetheless. SSI has certain tests. We're not going to spend a lot of time on that in the interest of time today. So I want you to use this as a tool to educate yourself about some of these tests. And I know many of you are concerned if your child or loved one has not applied for SSI. I know you're very concerned about whether they will be approved. Elville and Associates works with outside counsel to help you deal with the Social Security issues at hand. So we try to identify the best experts that we can from outside firms who handle Social Security cases as their main practice area. So just know that we can direct you in this area as you have need to be advised. These are disability definitions. I'm not going to spend a certain amount of time on that because we just mentioned that the SSI resource test was 2000. Notice that a person on SSI can have an automobile. This is not saying they should own an automobile, but they could own it. Their supplemental needs trust could also own that automobile, of course, or a van or whatever that vehicle may be. And they also can own a residence and still be on SSI. They could own a residence in their own name. That doesn't mean that that should be the case, but they could. Of course, SSI pays in 2023 $914 per month. It's supposed to be for food and shelter. Many of you are familiar with the SSI situation and how to deal with it. For those of you who are not, we would cover that in a further counseling session. But SSI is very important. Statistically, studies show that this is a very, very vital benefit, even though it doesn't seem like very much, especially in some of the more expensive places to live, which certainly Maryland is one of those. But places like California, $914 is not going to go very far. So many people have questions. How does SSI work in juxtaposed with the special needs trusts situation? How does it all work? I promise there are answers to that, and we can discuss that in a further counseling session if you need such advice. When we are dealing with SSI, we know that our loved one could lose their SSI. There are these concepts of earned and unearned income. There are concepts of our loved one earning so much money. If they are now happily working and being productive in their lives, they can eliminate their own SSI. They can make too much money and reduce their SSI to zero. So we want to be cognizant of these rules. And I know that's one thing that many of you struggle with. Your loved one is happily working and feeling good about their lives and hopefully enhancing their lives and moving forward in life. But as they do so, in some of your cases, SSI may be eliminated because your loved one is making too much money. And this is a good and bad thing in many cases. So this is just something we continue to deal with. There are concepts of in-kind support and maintenance and deemed income. So just know, and many of you have experienced this, that the most that you can lose, as long as your loved one is not over scale, they're not over scale with their $2,000, is 1/3. So if the trust is, for example, is paying for food and shelter, but remember SSI is supposed to be for food and shelter, SSI will reduce the benefit by 1/3. So this is a maximum amount. It can't be reduced any further on this particular issue. And so just understand that there is this 1/3 reduction, but there are ways of working around that so that the 1/3 reduction will not happen. So just understand these basic concepts and use this as a tool. SSDI, same thing. We're not going to spend a lot of time on these definitions. This is the disabled adult child definition that I mentioned a few slides ago. Disabled prior to age 22, the 50% of the parent's Social Security during life after the parent's retirement, and 75% after death. This is a very important thing for you to understand and will give a lot of peace of mind to you in the future as we all are getting older. Medicaid and Medicare, these concepts are well beyond today's scope of discussion, but these are basic tools that I want you to understand if you have some time to review this privately. Housing, again, is one of the greatest concerns that many of you have. And in a counseling process, in the estate planning process where we are planning for special needs as part of estate planning, this is something that is oftentimes one of the biggest subjects, whether you plan to leave your own residence for the benefit of your child, or whether you plan for your trustee to be able to purchase a residence and inside of the trust, let's say after your passing, or whether you are a family that knows your loved one will not live independently and you know that you're going to be relying on other housing type arrangements. These are counseling issues, including Section 8, that we discussed. So housing is one of the big issues for you, and we understand that. Okay. Now, Jeff, I'm going to stop just a moment because we are at part 3 of the presentation just to see if there's any questions. And we're going to launch into the special needs trust discussion, which I know many people on the webinar are waiting for.
Thanks, Steve. I do have some questions I want to get over to you. And let's start with what age should you establish guardianship?
Thank you for that question. Of course, none of the questions that I may answer today are legal advice because there's no attorney-client relationship and I don't know all the facts and circumstances of your situation, but I'm going to make a few assumptions if that's okay. If we were in a quintessential situation where someone is in a household where you are the parent and your child is in your household, you are the natural guardian of your child until age 18. And then 18 is the age where we are having to deal with the issue of your child has now become an adult in the state of Maryland, and they have the rights of an adult, and that's when guardianship would be considered. You can start the guardianship process about 2 months ahead of time prior to your child's 18th birthday.
Okay, thank you. Referencing the financial advisor question that we had earlier, are the financial advisors that we know fiduciaries?
Thank you for that. The answer is many of them are, and my assumption is almost all of them are. Each broker dealer has their own rules and regulations and policies, but my experience has been that most of them are. And for example, if I were serving as trustee of a special needs trust, supplemental needs trust, I would not invest assets with a financial advisor who was not a fiduciary. If for no other reason, then I myself would have fiduciary responsibility, and I would want that financial advisory firm to assure me through an investment policy statement that they are also understanding my fiduciary duty and that they themselves are a fiduciary. So thank you for that question.
Okay. Next question. My family set up a third-party special needs trust for our disabled niece. My question concerns her potential move from SSI to SSDI when one of her parents retires soon and starts drawing Social Security benefits. With the less restrictive guardrails when SSDI, should we also set up a personal trust for her future use? And where could we find more actual facts about SSDI with the SSA website being withholding of what the rules are concerning allowed income?
Well, that's a great question. I'll try to be helpful on that. I'm not quite following you where this other trust might be set up. I understand maybe there's a concern about when the child is receiving more money than SSI, what happens with that money. So I think there's ways, if I'm understanding your question correctly, I think there are ways to deal with the fact that the child, I'm perceiving your concern as being the child might have too much money and it won't be spent down and we're going to have to manage that money. So perhaps ABLE is a good alternative, the ABLE account. Perhaps the child will be spending down more of that money than we think. I'm not really following you with regard to another trust. Now, of course, a child could have more than one supplemental needs trust, and maybe you're thinking in terms of that money going from the child to someone else, and then that person contributes that money to the other trust. Maybe that's what you're thinking, I'm not sure. And then with regard to SSDI, there is something called the POMS, the Program Operations Manual for Social Security. So you can Google this, I believe it's public record, and you can go in and look at the Social Security POMS. You can actually look at the regulations, and it's pretty searchable, in my opinion. And the other resource that I would mention to you that might give you some information that you're looking for is Elder Law Answers. So Elder Law Answers is a attorney subscription service that we belong to and have belonged to for years. It's run by a gentleman out of Boston named Harry Margolis, who's a very devoted elder law attorney. And Elder Law Answers is a public website where you can go and pull up some of this information, and hopefully you'll find articles on that. I hope that's helpful in some way.
Okay. Next question. Annual plans through DDA and Medicaid seem to take forever to get approved. Any advice? Trying to get my brother into a self-directed plan.
That's a great question. Thank you. My advice would be to deal with, let's say, a specialist, and I'm using that word very broadly. We have an elder law paralegal, or a special needs paralegal here at our firm, Jane, and Jane is someone who has a lot of experience dealing with waiver applications and so forth. So I would recommend perhaps speaking with her. And she's a wonderful lady who has a special needs loved one of her own, and she could possibly be of help to you to try to navigate that.
I would agree with that, yes. Next question, can a special needs trust be funded with a rollover from a 529 plan if the beneficiary is the same for both? Is the rollover money taxed, and does the 10% penalty apply?
Well, thank you for that. So most of that question is beyond my ability to answer right now, but the first part of it is, to my knowledge, you could not roll over money from a 529 plan to a special needs trust in the sense that I think you're talking about. So you can roll out $17,000, which is the new annual exclusion amount, and the amount that Maryland Able says can be funded annually into an ABLE account. So that's the new 2023 amount. You can kind of roll out $17,000 out of a traditional 529 plan into an ABLE account. But you can't roll out, let's say, money from a 529 to a supplemental needs trust. I'm not saying you couldn't work with the financial advisory company and take out money and then recontribute that money to a supplemental needs trust, but you wouldn't be able to, to my knowledge, roll it in the sense that I think you're referring to. So that's something we could take up outside of this webinar. But that's a great question, but you should know that you can at least roll over $17,000 out of a 529 into an ABLE account, which is not a special needs trust, but is a part of the 529 system for achieving a better life experience.
Okay, let's try a couple more briefly, and then we'll move forward. My son has been receiving SSI for several years, and both his mother and I have now retired. Should we look into transitioning him to SSDI now? His mother has started taking her Social Security, but I have not yet.
Okay, so my guess, based on your situation, thank you for that question, is that yes, the answer would be yes. I would call Social Security, and I don't know how recently your spouse began Social Security, but I think that the mechanisms there are probably already in the works to get this started, even though they may not have contacted you yet. So based on what you've told me, I think the answer is yes. And now the path is clear to go ahead and make that transition happen. And I'm not quite sure why they haven't already contacted you. Maybe this flew under their radar screen, but I usually don't see that being the case. So if you haven't heard from them and there's been no communication about this, I would go ahead and start that.
Okay, and last question for now. If two parents of a special needs loved one are living, but one is already cognitively incapacitated, at what point is it imperative for a sibling or other to be named an additional guardian?
Thank you for that. Very, very good question. So it sounds like there's a guardianship in place. One of the parents is aged or has become incapacitated, and the other one, that doesn't sound like, is a young person. So what I would do is we need to look at you need to look at the guardianship in the sense of your well parent, which I'm assuming is a co-guardian, is the person who's continuing to be the guardian. We want to make sure from a special needs planning point of view that they have appointed further guardians in their last will and testament. So the Maryland court, if we're talking about Maryland, will generally not allow a standby or successor guardian to be named. They won't allow that to be named in the guardianship order. So you have to make sure your parent executes a will that says, at my passing, I'm appointing further guardians, and that's going to be kind of the stopgap measure. Or, in my opinion, you could petition the court now and say, your parent could petition the court and say, one of the guardians is incapacitated. I would like to appoint a further co-guardian, and see if the court would appoint you, I'm assuming, as a co-guardian with your parent, and in that way establish some kind of continuity, but not a successor guardian, but a co-guardian. And I think that's how I would address it.
Okay, great. Thank you very much, Steve.
You're welcome. Thank you, Jeff. Okay, in the interest of time now, I'm going to get right into special needs trusts. Many of you are on this webinar because you want to see this portion of the presentation. I want you to focus on the first column going left to right, third-party trust. So a third-party trust is where you pass away or another person in the family passes away and leaves money to your loved one in a third-party special needs trust. Now, the terminology here, not to get hung up on this, the terminology is this is generally called a third-party supplemental needs trust. Now, notice that anyone can establish this, and it is your money or a third party's money. And this could be life insurance. It could be non-retirement assets like cash or investments. It could be an IRA coming from you or this third party from point A to point B directly to that third party trust. And that is the bread and butter of supplemental or special needs planning. Upon the death of your loved one, it will go to the persons or organizations of your choice according to your wishes. So that again is the fundamental bread and butter of supplemental needs trust or special needs trust planning. The second column and the third columns here, as we go left to right, are called first party trusts. These are trusts where the disabled loved one has received money that they should not have received. They received an inheritance from you, or they accumulated too much money, or they received an IRA from a well-meaning relative who left them money outright. It knocked them off of benefits. So let's look at the one that we are most concerned about generally, the first party trust of the D4A type. Now, this is in the US Code in 42 USC, the United States Code. And in the interest of time, I'll just say this trust can be established by a parent, a guardian, a court, a grandparent. It could even be established by a high functioning disabled person. Now, there is a payback to Medicaid or payback to the state. So these trusts are payback trusts. The third party trust is the bread and butter. The first party trusts are payback trusts. You may be more familiar with these if I say these are the kinds of trusts that a disabled person would receive if they were injured in a car accident or a train accident, or they were injured at birth or a medical malpractice case. These are the kinds of trusts we're talking about. So the third party trust, again, this is the best way of leaving assets for your loved one. This is that world that we're creating for them. And it's a third party trust because it's established by someone other than the special needs loved one. Some families make these mistakes, and I know you won't do this. They leave assets outright to the loved one. This causes a loss of benefits, cause confusion. It could even cause a financial loss of the money that was left. Fortunately, we have the first party trust that can be a stopgap measure to make sure that that situation is dealt with and the loved one can get back on their benefits. Many times let's look at this second bullet point. Many times I look at special needs trusts that are brought into our office and I'm asked to review them. And I'm somewhat surprised that many of these trusts, which families relied on as special needs trusts, are really not trusts that protect the child. These are non-qualifying trusts. These are trusts that are really not exempt. These are trusts that are countable. So we want to make sure that doesn't happen. Some people take the approach, I'm just going to disinherit my child and leave the money to another person. Now, don't fall into that trap, and here's the reason why. Let's look at these bullet points. What if the person that the money was left to, whether it was a sibling or a friend, what if that person had creditors? What if they had bankruptcy? What if they had a car accident and someone sued them? What if they died and then left the assets to someone? They didn't mean to do it, but they passed away. They had no estate plan, and it went by the laws of intestacy to someone else or by way of their will, if they do have a will. What if the person is a sibling, but that person is not really the kind of person who wants to step up to the plate to take care of the loved one? Now, I know in many of your families, we have wonderful children who are siblings who are stepping up to the plate and they want to take on and they care for and love their sibling and they want to take care of them. But in some families, this is not the case. So we want to make sure we're not leaving money outright to such a person. Or what if the person gets divorced? What if the person has an IRS lien and the money is lost to Uncle Sam? So I could go on, but you get the point. Don't do this. We don't want to leave money to a third party outside of a trust environment because the money could be lost in many different ways. So again, the third party trust, the person who with disabilities did not create the trust. They are not the trustee of the trust. They have no demand right over the trust. The trust is a discretionary trust. So again, there's no payback. This can be revocable during your life. It could also be irrevocable, but many times today we create these third-party trusts as revocable, and we want to draft flexibility into these trusts. Choosing a trustee, Jeff and I put on a webinar about this. Jeff will be happy to send you a link to this very important topic, about this topic. Now, there could be family members, there could be professionals, there could be other specific professionals like attorneys that are trustees. I just returned from the Heckerling Estate Planning Conference earlier in January. I thought it was a very powerful conference this year. It was the first time in years that we had met in person. And one of the elder law presentations was about special needs planning. And there was a certified elder law attorney who presented, and she herself has a special needs child. And I thought it was an extremely powerful observation on her part that, in her opinion, professionals should serve as the trustees of special needs trust. And this is not always the case, of course, and this is not always what happens. But I found it very interesting. Her point of view was that family members should really be advocates for the loved one. They can be advocates and they can be trust protectors, which we'll talk about in just a moment, but they should not necessarily be the trustees. Now, this is going to vary based on your own family situation and your desires, but I just thought I would share this unique insight from a certified elder law attorney who is a mother of a child with disabilities. I just thought it was an excellent observation. But it's always going to be on a case-by-case basis, and we have to weigh the difference between an interested trustee, like a family member, versus an independent trustee. And these are some of the factors that you should think about. A trust advisory committee is a provision in a supplemental needs trust that says if your trustee needs advice, if they need advice, not just from a professional, because remember, a trustee can hire professionals and they need to understand that they can. This is a broader situation. This person needs advice about a subject that has become ambiguous. It's just something that the trustee can't get their minds around. And this trust advisory committee can consist of several key players. It could be a pediatrician, it could be a psychiatrist, social worker, advocate. These people can come together to advise the trustee if it is necessary. The trust protector. The trust protector is a third party. This should be an independent person most of the time. However, those of you who are really listening a moment ago just heard me say that a family member could be a trust protector. So the trust protector concept is that there is a third person, usually an independent person, who can make certain decisions, who can direct the trustee in certain decisions. One of the most important things they can do is have the ability to remove and replace trustees. If a trustee is no longer appropriate, they need to be removed. A trust protector can do that. That will give many of you peace of mind for the long-term future that you have installed this kind of special fiduciary in a special needs trust. The trust protector can also do something extremely important, which is be able to amend the trust. So many people don't think about this, but a supplemental or special needs trust is going to be, they're going to need to be amended over time. For example, the Secure Act. This is a very big retirement plan bill. This bill continues to evolve and it affects special needs plans. And we're going to talk about that in just a few minutes. You're going to want a trust protector, even though a trust protector is not required. You're going to want, in my opinion, a trust protector to be installed in your plan to make sure there is flexibility as things change into the future. You may also want your trust protector to review accountings and have other powers, such as the power to mediate disputes and other things. So these are very, very special things that are part of the modern counseling process in special needs planning. If I could draw this for you, I would draw it just like this. And I would say this is kind of the contemporary structure of a special or supplemental needs trust. If we go from actually right to left, we see we have trustees, very important, trust protectors, very important to think through that process, to have able account provisions in the trust that authorize the trustee of the trust to fund an able account. Advocate provisions, a provision that says, listen, trustee, don't forget you can hire an advocate. And the advocate can make sure the loved one is being cared for and monitored and their vital signs are being taken and they are eating properly and whatever else needs to be monitored. The memorandum of intent, which can be attached directly to the back of the trust. And if you keep this in a Word format, this can be something that can be updated every 5 years or so. We just talked about the Trust Advisory Committee. And supplemental or special needs trusts need to have retirement plan provisions because of the Secure Act and because persons with special needs or chronic illnesses are exempt from the Secure Act, which means they can stretch out retirement plan benefits and they can stretch out the taxation of those benefits throughout their lifetimes and not be limited to the new rule, which many of you have heard of, where your healthy beneficiaries, if they're not exempt, they are going to be subject to the 10-year rule. Jeff and I searched high and low as we look for photos of what we might call the special trustee, or the perfect trustee, I should say. A trustee who is beyond reproach, the perfect person. And so these two individuals, they represent those kinds of trustees. And I'm being facetious, of course. But I'm not kidding about these concentric circles which are in the middle of this slide. So as you search in the process of who should be your trustee, I want you to think about their duties. A trustee is going to advocate. They are going to be accountable. They are going to understand financial affairs. This person is going to always work for the best interest of the beneficiary and promote independence and understand public benefits. Keep accurate records. All of the things that you would expect. But here's the key. We don't want the trustee to be doing these things on their own, unilaterally. We don't want them to be going it alone. We want the trustee to understand the trust. So first of all, they need to read it. They need to understand these concepts, and they need to understand maybe the most important thing, and that is that they have the ability to hire professionals. So we don't want the trustee who is probably a non-professional in many cases, or a non-professional trustee. We don't want them to go it alone. We want them to understand their duty and to act accordingly in hiring and utilizing professionals. A special needs trust, which is a first-party trust by definition, can pay for certain things. Jeff will be happy to send you an overview. It's not inclusive of everything, but it is a good example of what a special needs trust can pay for. The third-party supplemental needs trust is broader in concept, and it is something that can be used for the benefit. Of course, it would be used for the benefit of your loved one, but it can pay for basically anything for their benefit. One of the key financial issues is how much should I fund into a special needs trust? Do I treat all of my children equally? Do I leave a disproportionate share to my loved one with special needs in their trust? Should I use life insurance as a funding tool? So again, I want you to use your financial advisory resources that are available to you. If you don't have those resources available, let us know and we will help you. We will help you as you formulate your ideas and what you need, and we'll make those help make those resources available to you. As I mentioned, the first party trust is a tool. If your loved one receives assets in ways that are unanticipated, they receive these assets and they are disqualified from their public benefits, understand that a first party trust can be established. There is a pooled trust. Many of you have heard of this. Pooled trusts are lower cost methods of dealing with this, and they are trusts that can be established for individuals who are over age 65 and not just under 65. The D4A type trust, this is the type of payback trust where a person has to be under age 65. It is the most commonly used trust that we deal with here at Elville and Associates, but we need to be cognizant of both of these kinds of trusts. I will say, in the interest of time, a special needs trust of the first party D4A type, it is a best practice to go ahead and establish one of those first party trusts and have it sitting there and have it available just in case your loved one were to get assets that you don't anticipate that they would receive, but they received these assets. Now we have a place to get those assets out of the name of that loved one who is under age 65. So in best practices, we would have a third party trust and we would have this standby first party trust just in case. But these are payback trusts, and we want to be very careful that we're not funding a payback trust. I mentioned that these trusts come from personal injury awards where someone receives an inheritance they're not supposed to receive. So again, this point at the bottom, we may want to implement one of these trusts just as a best practice. It just sits there. And then we have the third party trust, which is really the driving force of our planning. So let's talk about now, as we start to wind down, we talked about process, and this very odd graphic, which is supposed to be going from left to right, shows our process. And in the interest of time, I'll just say that whether it's estate planning or estate planning that involves special needs planning, we want to be driven by a process. And when we're driven by a process, whether it's flying an airplane or we're getting ready to take a trip somewhere, or a doctor who's getting ready to perform surgery and goes through a checklist, when we have a process and we're driven by that, then we're not going to leave any stone unturned. So planning is a process. It's a lifetime process in many cases, and the process of education never ends. And here's the key: the process of education for your fiduciaries never ends. So when you start thinking about planning, we want to think of it as not a transaction, not a quick transaction, but a process of education and a thought process of what is the best and highest planning and how do we get there through the right thinking. These are just some steps that we take at Elville and Associates in the process. We talked a little bit earlier and I went into some depth, which is why we're running about 5 minutes behind here. We are in the process of always deciding about what is best for self-determination for our loved one, and we want to carefully consider guardianship versus no guardianship versus supported decision making, which I won't go into any other detail here. Just know that Maryland now has a very broad supported decision making statute. Many people who would have gone under guardianship will not go that direction now. That will not be the case for them. Many people who are under guardianship may have that guardianship terminated because of supported decision making. Many people who will be under guardianship will have a supported decision maker where they will be recognized as having more rights than they had before under guardianship. And then those who have higher capacity to sign advanced medical directives will have those agents under medical directives and powers of attorney, but also have a supported decision-making agreement. So I want you to, again, to think in terms, when we're talking about guardianship and capacity, to think in terms of this continuum, left to right or right to left, however you have structured that in your notes. There are two types of guardianship: the guardianship of the person and the guardianship of the property, or as we refer here, guardianship of the estate. Again, this is a summary of supported decision making. I think that the best thing for you to do is to go on our website and look at my article. I was very careful to try to include all the legislative bullet points in my article, which is rather long, but I think it is a good way for you to get your mind around what is this concept and what would it mean to me and our family and our loved one with disabilities. So I want you to think in terms of a memorandum of intent. Yes, it's a lot of work, and I know how much work you already put in, and I know how busy you are. We are going to give that to you if you'd like to get your thought process started on your memorandum of intent. We want you to establish your own estate plan, of course, and as part of that estate plan, evaluate where and how should I establish my supplemental needs trust. Should that trust be embedded in the revocable trust or will, or should it stand on its own, which is obviously the highest and best thing, is to have a standalone supplemental needs trust for your loved one. We want to think about financial planning and financial needs. And again, we want to make sure that the supplemental needs trust is optimized for the Secure Act so that your loved one will not have accelerated income tax when they receive your retirement plan, your IRA or 401k that comes into their trust. We want you to understand public benefits, and we know you do largely if you're a parent, and we want others in the family to understand, and we want trustees and other fiduciaries to be educated about public benefits. We obviously want to calculate and plan for the future, including housing. We want to install advocates now and in the future, and this is challenging. We are not here to minimize this. This issue of establishing advocates is one of the challenges of our time, and we don't want to be unrealistic about that. That's why we want to work through it and labor through it to try to find a solution. But building flexibility into the plan is going to get us where we need to be, as close as we can to giving you peace of mind and giving security to your loved one. And of course, the special needs trust should be part of the plan because the structure is going to be achieved through a lifetime of education, education of fiduciaries, and your willingness to work through a process. And that's what we're trying to convey here this morning. So we want you to set an appointment to review older plans, or to start the process of helping to formulate what our goals are, which I'm going to get to here in the bottom bullet point. We want you to complete an estate planning questionnaire. So the basis of all good planning starts with an estate planning questionnaire. More work, we know, and we know you're very busy, but that is really the basis of everything. The information that you share, and along those lines of sharing, I want you to understand that this is something that is unusual. It's not normal, right? To meet with people for the first time that you've never met, share personal information, and share very, very confidential information. It's very unusual. So we want you to relax. We want you to understand something. When you consult with an attorney, when you consult with us, if you do, we are in an attorney-client relationship. Even if you decide not to move ahead as a client, when you meet with an attorney and you share information, that information is confidential, and an attorney-client relationship was formed at that time whether or not you decided to move forward and become a client. So there is really nothing to fear, and we want you to know that. Bring your current documents and let us review those documents. Generally speaking, we do not charge to review documents. So I've reviewed, for example, in myself, I've reviewed thousands and thousands of documents. It doesn't take me very long to review documents. We're happy to review them. We want to help you form an advisory team. I know I've been saying that throughout the presentation, so I want to drive that home. Don't be shy to let us know you would like to evaluate a new team or a team. And we want to answer your questions. If you come in or even after today, please give us your questions. We're happy to help to try to answer them. And when you come in person for a consultation or by a video, whatever it may be, please have your questions ready. We're happy and we like to answer questions. And lastly, we want to give you time to think, as I mentioned earlier. Some people know what their goals are. And some people are not quite sure yet what their purpose and their goals are in this planning. Some people have to have a lot more information to be able to formulate their goals. So we want to help you do that and think through that, and you'll have epiphanies. I assure you that if you're willing to sit in a counseling partnership relationship where you share information and receive information and you work together with us, I promise you that you will have epiphanies, and we will work toward answers to help you formulate what your ideas and goals are for your own planning and for peace of mind, protection, and all of those things. So with that said, I thank you for spending valuable time with me on this Friday morning. I wish you a happy weekend ahead. Please stay warm and let us know what your questions are. Jeff, this is a wonderful audience that have asked great questions. I'm going to turn it back to you now, and thank you too.
Thank you, Steve. Very well said. Appreciate the information as always. Always a great presentation. And we do have many good questions that have been asked, and we have some more good questions here that I'd like to go ahead and pose to you so we can get some answers and some feedback. So let's go ahead and begin. First question we have here is, if both parents are retired, does a child receive the Social Security supplement based on both parents' retirement or just one?
That's a wonderful question. To my knowledge, it's always been just one. So that's a great question. Thank you.
Okay. Could a child who receives SSDI qualify for their parents' Social Security upon the death of the parent?
Yes, so thank you for that question. Just to clarify, because I know I was going pretty fast through that material there at that point, when you pass away, your loved one, your child with disabilities will receive, if they are a disabled adult child, they will receive 75% of the amount that you were receiving at your death.
Okay. Next question. I did not get guardianship when my child turned 18 years old. He is now 39. Is it too late?
Wonderful question. Thank you. The answer is no. So if your child is truly a person in need of a guardianship, meaning they have no capacity, they would be deemed to be a person that's incapacitated for purposes of understanding their own decisions as determined by a court, and by determined by two physicians that say, as proof, two physicians that say your child is disabled, it is not too late at age 39.
Okay. Regarding ABLE accounts, can you fund the ABLE account from the Special Needs Trust?
Excellent question. The answer is yes. So that is one of our more modern techniques now, is to make sure that in a first-party trust or a third-party trust, that we're adding provisions that say the trustee can fund an ABLE account.
Okay. Next question. Our son is receiving SSDI from his father's Social Security. When I claim my Social Security next year, mine will be greater each month. Can we move him to my Social Security with any ease? Is this a good idea?
Oh, thank you for that. To my knowledge, your son will receive the higher amount, meaning as a disabled adult child, he would receive the higher of the two amounts based on that formula. And I don't see any downside of doing that. Not knowing your situation, I wouldn't imagine that there's any downside of doing that. So if you're successful which I hope you will be with very little trouble speaking to Social Security about that, I think that will be the answer. I think that'll be the case.
Okay. Does the parent's income come into play when applying for SSI for a disabled 13-year-old?
Thank you for that. The answer is yes. So for a child who's under 18, it's going to basically be determined by the household impoverishment rules. And so my general answer is going to be yes. So most children, of course, receive SSI at age 18 or beyond, but it is possible for a child to receive SSI under 18, depending on household resources and income.
Okay. Regarding special needs trusts, if you're the trustee of a special needs trust, at what point can you name a beneficiary?
That's a great question. Thank you for that. The answer would be that in a very, very general and broad sense, a trustee cannot name another beneficiary. So this is kind of a qualified answer, of course, and a very general non-legal answer, really, that a trust could be drafted where a trustee could be given discretion, such as, I'm allowing my trustee to distribute money at my child's death among several people, and I'm going to give them the discretion to give certain amounts of money among these people. So that would be an example of giving the trustee discretion to do certain things with regard to distributions. But notice that in that example, the trustee was not given the authority to choose who the beneficiaries are. So if I'm understanding your question correctly, a trustee could not choose, so to speak, a beneficiary or create or add a beneficiary in a general sense. Now, with that said, each situation is different, but I would not think in terms of a trustee having the authority to designate a beneficiary.
Okay. Any thoughts about common mistakes people make when people set up a special needs trust or execute it?
That's a great question. Jeff and I are getting ready to do a webinar with a financial advisory firm about this issue, the most common mistakes that people make. I would say the most common mistake people make probably has to do with incorrect selection of trustees. But I will even get more fundamental. I would say their most common mistakes have to do with lack of understanding, really nailing down an understanding between a first-party trust and a third-party trust. That's a real big problem area. And sometimes attorneys who are not on top of their game confuse people with this, and this causes great confusion and problems. The other big issue, I guess, and there's probably 7 or 10 different issues, but another big issue is the problem of funding. So a person, first of all, has to understand exactly what kind of trust they're establishing. They have to have lots of confidence in their fiduciaries and understand what is good and what is not in the structure and make sure those fiduciaries are educated. But we also want to make sure that in the funding and alignment of assets, remember whether you have a will or you have a revocable trust, at our deaths, assets are going to flow. And we have beneficiary designated assets, we have non-designated beneficiary assets, we have all kinds of things going on. And then our financial advisor friends many times need to make sure that when they are helping clients title assets, that the assets are going to flow properly based on what the desires of the client are and what the structure of the will or trust is. And we want to make sure that everything is flowing in the same direction. So I would say those are the most fundamental risks. Understanding the difference between the trust, fiduciary selection, and making sure that assets are flowing properly at death, and not just perfection in the documents, but perfection in the way that assets are actually going to flow.
Okay, very good. Next question, what should be factored in when deciding which should be part of a special needs trust? Are there reasons to include or not include a home where the person is living, for example?
Yes, that's a great question about counseling through the process. Your particular situation, whether or not your loved one will continue to live at home, and whether or not you should leave your home in the third-party trust for their benefit, and who will pay the expenses of the home after that, and will the person need assistance in your home, and what will that living situation be? That's a very powerful issue there that has to be addressed. And I apologize, Jeff, I lost the last part of that question.
What should be factored in when deciding which should be part of a special needs trust? Are there reasons to include or not include a home where the person is living?
Correct. So I think I talked about the last part, but not the first part. So the first part of that question is you're going to look at your financial world and you're going to decide, are you going to drive non-retirement assets to the special needs trust? Or if you're a person who has a lot of retirement type assets and you say, well, if I drive these assets to the trust and my child is qualified as what is called an eligible designated beneficiary, which is the new class of persons who is exempt from the Secure Act, then perhaps you would drive more retirement assets to the special needs trust than non-retirement assets. Whereas if you drove those retirement assets to another beneficiary who is not exempt under the Secure Act, they would have to pay accelerated income tax. So all of these things factor in, starting with what is the makeup of your financial world from the beginning. And then we decide what are the shares and what should be driven into the special needs trust. And lastly, whether life insurance should be something that's part of the planning to ensure that a certain amount of money is actually going to reach that special needs trust, because none of us really know how much money we're going to have actually at the time of our deaths.
Okay. And a couple more here before we wrap up here. What is the best way for an ABLE plan to work in tandem with a third-party special needs trust?
That's a wonderful question that many clients have. I would say, generally speaking, and by the way, for those of you who don't know, the age for qualification of an ABLE account is going to increase to 46, which has been talked about for many years now. From age 26 to 46, I believe it's going to happen in 2025 or at the end of 2025. So just know that that is going to happen, and that's a good thing for many people. I would look at, if this is a good answer to your question, I would look at the third-party trust as the world, the supplemental world that you're creating for your loved one. And of course, this Achieving a Better Life Experience account is not a payback account in Maryland. Remember, the third-party trust, no payback. The ABLE account, no payback. But remember, under the federal laws, ABLE is a payback account. So that's just something you have to think about. It's for enhancing the quality of life of your loved one. It's going to depend on their level of disability or high functionality or lack thereof, and how much that account is actually going to benefit them, and whether or not they are in HUD housing, which there's an advantage to use the ABLE account, whether you enjoy the tax advantages and the tax-free income and so forth from an ABLE account. All of that will weigh in, and I would say in many, many cases, and of course the vast majority of the cases, a family will very much enjoy establishing a third-party trust in tandem with an ABLE account, and now we kind of have the best of all worlds. But there are things to understand depending on whether your child is under guardianship, whether they are not under guardianship, and how much money is going to be pumped into the ABLE account over the years. All of these are counseling issues, because these issues have to do with who actually owns the ABLE account and whether or not the child should have access to it as an owner if they are not under guardianship.
Okay. And last question for now. I am a legal guardian. Both parents are indigent. I said that right?
Yes.
Or on public benefits. Can my grandson still get SSDI?
Well, thank you. That's going to be a fact-specific question that I think I'm going to have more answers to. I think the fact that you are the guardian, from what I'm hearing, both parents are indigent, and I don't know the age of the child, but that would be dependent on this. But it seems to me like it's a pretty optimistic situation for the child to get SSI. So I'll just take the very limited information I have and say it sounds optimistic, but we'd have to have more facts. But thank you.
Okay. Okay. Okay, very good. Well, thank you for all the great questions. Very helpful for everybody. I have a lot of information to share with you. Steve mentioned many things that could be sent out to you. I actually have everything ready to send to you. I did because I already knew what Steve was going to say. So it's already drafted and ready to send. It includes, just really briefly, slides again, the video, the letter of intent, the memorandum of intent, the document reflecting the uses of special needs trust, Kevin Urbash's book, the link, many of our webinar links, the link to Steve's special support decision-making article, a link to our upcoming presentations, and a couple more things. So that is ready to go. It'll be coming out to you very soon. I just need to wait for the recording to upload, and we'll be ready to go. So with all that said, thank you for being part of a great presentation today. Thank you to you, Steve, and all of our attendees.
Thank you
And
to
we
everyone.
appreciate your interest in Elville and Associates in our webinar series, and we certainly look forward to hosting you soon, and hope you have a great weekend. Thanks very much.